Welcome to everyone joining us on this Tuesday before Thanksgiving, Thursday. We have a great presentation for you today, so let's get right into our topics. Next slide, please, Kate. So we're going to start with the current COVID data and where we are in terms of COVID cases in New York State. As you can see, we're looking at, as of yesterday, a daily average of 4,178 cases. That is down by approximately 7% over the last 14 days, which is very good news, but it looks pretty flat. I was, in preparing the slides for today, I just looked at some of these charts, these same charts that I was doing back in January or February of this year, and we saw cases in the 60 to 80,000 per day range. So we've come down quite a bit, and we seem to have leveled off pretty clearly over the last several months. Next slide, please. Again, we look at our colors, and we like to see light colors. We like to see yellow. We like to see light orange. We don't want to see dark red or dark orange. We don't really see any of that on these charts. Interestingly, the New York City case description there, the 14-day change, it's described as flat, which is good. I mean, we're not seeing an increase in one way or the other. We're seeing other counties with flat cases as well. And we're seeing some decreases by substantial amounts in Orange and Chemung counties. Again, those numbers are a little deceiving because the population or the number of cases is significantly smaller in those counties. All right, next slide. In addition to providing the COVID update today, I wanted to go over a couple of questions that I got after I presented last time regarding COVID paid leave. There is still a lot of uncertainty about COVID paid leave among employers, very understandably so. So I wanted to address some of these questions. First of all, this question came up. How do I determine how much COVID leave I must offer to employees? So I don't think I did a good enough job last time distinguishing between private and public employers. For private employers, it's really based upon the number of employees you have and your annual revenue. So as you can see on the first slide here, if you have fewer than 10 employees as of January 1st, 2020, with a net income of less than $1 million, you don't have to provide any paid leave. You do have to provide job protected leave, but no paid leave. If you go higher on, go down on the chart there, 11 to 99 employees as of January 1st, 2020, or fewer than 10, with net income of greater than 1 million, you have to provide up to 5 days of COVID leave. And that goes up to 14 if you have more than 100 employees. For public employers, it doesn't matter the size. Public employers are required to provide up to 14 days of COVID leave per quarantine or isolation order. So I hope that provides some clarity on that question. Next slide, please. Next question I got a couple of times after the presentation was, if an employee can work remotely while isolated, do I have to pay COVID leave? And the guidance is pretty clear on this. No, you don't. But then there's a follow-up question, which isn't as clear. And that is, does this count as one of those three instances or periods that we talked about? And the answer is no, because you wouldn't be providing any COVID leave. So if you have someone who tests positive for COVID, they can keep working from home. They're not too sick to do it. And they do, then there's no COVID leave paid out. That does not qualify as an instance of COVID leave. Next slide. Do I have to pay COVID leave when an employee's child is under a mandatory quarantine or isolation order? And this is a really good question, and the answer is a little confusing, so I wanted to talk about it in a little more detail. The answer is no, you don't, because according to the statute, COVID leave is only available when the individual is subject to a quarantine or isolation order. However, New York State has made clear that if someone's child or dependent tests positive for COVID and you have to stay home to care for them, that could potentially qualify you for New York paid family leave, which is the insurance that everyone in New York State has to have for their employees now. The eligibility is the same as it is for other paid family leave absences. So that's something to keep in mind as your employees are coming to you with questions about COVID leave. We'll continue to address questions if you have them, but I just wanted to touch on those few questions that I've gotten since I presented last time. So thanks again. All right, next up, we have an important gun law update. This is from Nick Jacobson. Nick has been on, Nick splits his time between Syracuse and Rochester. Nick's been on a number of times to talk about many different topics, this gun law in particular, but I know that there's been a recent development, so we wanted Nick to come on and provide you all with an update on that.
Thanks, Adam. Next slide, please. So just a recap, in case you've missed any of the developments with respect to New York's gun law. Until recently, to conceal and carry a firearm for self-defense outside of the home or business, individuals in New York were required to demonstrate proper cause for them to have such a license or permit. Proper cause required an individual to demonstrate a special need for protection that's different from that of members of the general public, such as specific threats, attacks, or other extraordinary dangers to that person. So it used to be, you couldn't say, I live in a bad neighborhood, or there's been a lot of break-ins and I'd like to, carry a weapon on me for self-defense. That used to not be enough. New York's proper cause standard was challenged in the Bruin case, and the Supreme Court held that the proper cause standard was an unconstitutional restriction on individuals' Second Amendment rights. Next slide, please. After the Bruin decision, New York passed new legislation, which was signed on July 1st and called the Concealed Carry Improvement Act. The legislation prohibits individuals from carrying firearms in certain defined sensitive locations, such as government buildings, healthcare facilities, religious institutions, libraries, parks, public transportation, and bars. The law also prohibited the possession of firearms in restricted areas, and restricted areas were defined very broadly as any private property where the owner has not posted clear and conspicuous signage or otherwise given explicit permission that the possession of firearms is permitted. Next slide, please. As expected, the Concealed Carry Improvement Act was subject to immediate legal challenge in the Northern District of New York. A temporary restraining order was issued by the court, significantly restraining enforcement back on October 6th. That court, with Judge Sotheby issuing the decision, gave New York State 3 days to request emergency leave from the Second Circuit Court of Appeals. New York State did that and was granted a temporary stay pending review by an appellate panel. Next slide, please. While the temporary stay was awaiting review by the appellate panel, Judge Sotheby issued a temporary restraining order, a preliminary injunction, again restraining enforcement of significant portions of the CCIA. The court in this case denied the state's request for a limitation on the scope of the injunction and the request for a stay pending appeal. The state again sought emergency relief from the Second Circuit and was again granted an emergency interim stay pending further review by an appellate panel of 3 judges. Next slide, please. So where does that leave employers and businesses? We've been kind of playing ping pong here back and forth between having the law be in effect and having the law be stayed. So what can employers and businesses do now in response of the fluctuating status of the law? Next slide, please. So while the law is currently in effect in light of the Second Circuit's temporary stay, the legal challenge is still in its early stages. There hasn't been any permanent decision issued regarding the enforceability of the CCIA or holding, what specific portions of it are going to be limited going forward. So really, This is a shameless plug for myself, but stay tuned for further developments, and continue to stay up to date with us here, because further developments are coming both at the district court level, at the Second Circuit, and very likely eventually from the Supreme Court of the United States. In the meantime, however, given the fluctuating status of the law and the likelihood of further changes in the status of the law going forward, employers and businesses might want to consider adopting policies and posting signage advising of their rules regarding the possession of firearms on their property, so that we don't have to sit and wait for the courts to make a final decision. Judge Sotheby, in initially granting the temporary restraining order, noted that one of his bases for doing so was that the new law took the decision out of employers and businesses' hands as to whether to allow the possession of firearms, and forced them to take a position and engage in speech as to whether or not to allow firearms on the property. And really, I think that's where employers are left now, given the fluctuating status. You might want to be proactive, adopt your own policies, post your own signage, and take ownership of whether or not firearms are going to be allowed or not, while the legal challenges to this law play out. Thank you.
Nick, thanks so much. Great update. We will continue to keep our eyes open for any more court activity on this issue. It seems to be rapidly developing, so we will let you know if anything changes. All right, next up, it's always good to have an expert on to discuss current events. So I'm sure all of you maybe have seen in the papers recently that there's been an issue regarding railway workers and whether or not a contract was going to be ratified and how that might impact, the Christmas season, supply chains. And we have many experts here at Bond who specialize in labor negotiations, union issues. One of them is Andy Bobrick. And Andy, I know you all know Andy. Andy was on hosted for over a year. And Andy is here to tell us a little bit about what's going on and give a little context that I think will be helpful.
Adam, thank you. Good to be with you. Good to be with everyone. Adam, I thought when you wanted me to come on and talk about current events, it was going to be the Tom Brady Giselle split. So I'm not sure I'm prepared to talk about the railway material today, but let me do my best. All right, here. All right, so just a few slides for your background. I am a full-fledged admitted labor geek and nerd, and Adam will vouch for that. And so this is an issue I've been tracking with that hat on also, though, because this issue has potentially enormous ramifications for our economy, and as well as for clients who I work with who have represented workers who are currently or will be at the bargaining table soon. So let's just set the table here in terms of this issue with the next slide and see what's going on. So you may recall there was a bunch of hubbub in early fall about the potential for a strike in the railway workers, contract negotiations that were underway at that time. And I think we're talking like 12 different unions, and it was a mass contract negotiation that was underway. And there was a strike deadline looming in the fall. With the intervention of President Biden and Secretary of the Department of Labor, Marty Walsh, there was a tentative agreement that was reached back in September to avoid that strike. And that's when probably you remember all the news hitting. And as I mentioned, there's several different unions who are ostensibly party to this tentative agreement and would be bound by this contract and thus have to ratify it, approve it. Through a vote of their members, right? The unionized workers in each of these bargaining units for each of these unions. And so what a tentative agreement or TA is basically that the parties are at the table, they're there in their representative capacities, and they've reached a comprehensive global agreement on all issues. And then they have to take that back to their respective sides, right? So if it's a corporation, maybe to their board of directors or their principals, or if it's a union, to their members to ratify. And typically you have a measure of confidence that that ratification vote is going to go one way or the other. Here, as I'll talk about in a minute, we saw some pretty significant movement in favor of the represented workers, things that they were looking for in terms of pay and benefits, enhancements there. And so it seemed like we were on a positive path where ratification is likely. Yesterday, some important votes took place with two of the largest unions that are out there in terms of this conglomerate of represented workers. You had the SMART Transit Division Union, represents about 30% of the workers impacted here, voted down, voted to reject the tentative agreement. At the same time, you had the second largest union that voted in favor of it, that represents about 20%. And prior to this, there were three other unions who likewise voted down that you may have heard the tentative agreement. So we've got this dichotomy present where we've got a large contingent of workers who have voted in favor of it. We have another large contingent of workers who have voted down and rejected the tentative agreement. So where does that leave things right now? And we'll see on the next slide, there are a few options in terms of the path forward here. All right, so effectively what happens if one of the sides rejects the tentative agreement? Well, then the parties are ordinarily back to the table to negotiate. And we're hearing discussions that could take place, likely will take place here. But again, once there's a TA, it's pretty common that, hey, we've kind of reached our end here, and this is what both sides are willing to give, and it doesn't necessarily leave a lot of room for compromise after that point, but doesn't eliminate it either. So that's possible. Congress also has the statutory authority to intervene here and to require the adoption of a contract to help maintain smoothness in terms of the operations of the railway, because it is such a critical part of our economy and infrastructure here. The other piece is that there could be a strike. And this, of course, would be a very significant development. And there are certain statutory cooling off periods that apply when there is not common ground found, and parties find themselves in the situation where you have a TA that's not adopted or accepted. For one of the unions, that cooling off period ends on the 4th, but eventually they could strike on the 5th. And for the other group of unions, that would be on the 8th, and they could strike on the 9th. And again, that's notable because I think that the prevailing thought and sense is, and I agree with it, is if one of these unions who rejected the contract strikes, that strike would be rejected by all of the other unions that are in place. And this would be truly a very significant event, could have very dire and negative ramifications for our economy, for everyone's lives, given how much, given the volume of products that are shipped through the railways and that transport through the railways, as well as the importance of those items to our everyday lives. And the estimates that are being tossed around is that the cost could be as high as $2 billion a day. So what's going to happen next? I think we have to stay tuned. The White House, and we'll go into a little bit more information on the next slide. The White House really finds itself in a challenging spot right now. They have to, I think, be mindful to protect the economy. Of course, that'll be first and foremost. They also have to keep in mind that the strike really would be dangerous and damaging to the economy and have a lot of negative ramifications. But at the same time, you have a president who was involved in this process to begin with, and as the next slide will show, achieved some very positive results intended for the bargaining unit, but is also closely aligned himself and the administration with organized labor. And you have a large contingent of represented workers in those unions who are saying, we don't like this deal. It's not good enough for us and our members. And again, going back, what you saw was a significant wage increase over the course of the term of the contract that was tentatively agreed to, almost 24%. over 4 years. You had a retro raise going back to 2020 of 14% and $1,000 bonus payment that would be factored in. And what represented workers would be looking at on average is about a $11,000 payment, just first and foremost, in addition to the increases that are contemplated there going forward for signing this. And so what are the issues now that are the sticking points? Well, they're some of the same issues that arose before that really weren't addressed through the intervention of the White House and advocates by way of proposals. And what the unions are pushing back on is that, hey, we've had so much attrition, staffing levels are so low, it's placing a tremendous burden on the remaining staff who are out there. They're having to be scheduled in ways that aren't predictive for them. It's having a negative impact on their life. They're having to work very hard, and they don't have enough paid time off to use. I mention these because I'm suspecting in many areas, these are some of the same issues that you may be dealing with. As the job market remains very tight, as employers have large numbers of vacancies that may exist in their workforce, they're having to rely on their current workforce to a greater extent. Certainly more I would expect than they'd like to, but nevertheless, that's the case. So just keep those points in mind. This is something we'll continue to monitor, and I'm happy to report back. And just in the meantime, wish everybody a very happy Thanksgiving. Adam, I'm very thankful to have you as a friend and colleague, my pal, and turn it back to you.
Andy, thank you very much. And that's an interesting insight by someone who negotiates these labor contracts regularly. So thanks for coming on. Okay, next up, we have Jeff Keel and Lou DiLorenzo back on to discuss some issues that you should think about when you are settling claims. So if you're going to offer an employee a separation agreement, or you are settling a claim with an employee, what are some things that you should think about in doing that? So Lou, Jeff, welcome on.
Hello, everybody. Okay, Lou, you seem to be muted, but you can unmute.
Yes. Hi, everybody. Sorry I have this bad background, but I had hip replacement surgery last week, and I've got to keep my foot elevated. So this is the only spot where I can do that and still participate. So I apologize. I wish we could tack on to Andy's presentation. That was fascinating. And of course, one of the things that drives you nuts in the situation everybody finds themselves in now is that both the government and the railroads, as well as the union leadership, agreed to that proposal and recommended it. And now when you go back to the drawing board, the question is, how much control does anybody have over where this is going to go? Very disconcerting when the leadership agrees to it and they can't deliver the votes from the membership. It means there's a disconnect between what they believe they would take and what they actually would take, which is scary. Okay, settling claims. The reason Jeff and I thought this would be a good topic to talk about today is, unfortunately, we have a number of companies that are getting involved in layoffs. If we face the recession that the Federal Reserve seems to be trying to push us towards with these increased interest rates every quarter, they may get us to a recession where we may see some layoffs. There's a number of industries that are cooling off, not just the tech sector. And so the question becomes, how do we get rid of claims if we pick people for layoff? And even if they're not picked for layoff, Jeff, how do we handle individual claims, settlement agreements? Good to dust these off. There's been a number of changes in the law. And, you know, Jeff and I and others continue to see people use old agreements, and there's been changes in the law, and sometimes the significance of some of those changes is realized. And obviously, if we're paying money under a severance, we want to make sure.
Hold on a second. You're cutting in and out a little bit. I think it's because you're muffled. I don't know if you have your hand over the mic.
I don't. Let me see if this
there you
is
go.
Any better.
That's better.
Is that better?
Yeah.
I guess it wasn't close enough to it.
There you go.
Okay, sorry. So, Jeff, why don't we talk a little bit first about some of the complications that come from this Older Worker Protection Act. Back in, I think, the 80s, maybe 90s, Congress passed the Older Worker Protection Benefit Act. And the reason it was passed was I think there were 10,000 Chrysler, middle management Chrysler people called in on a Friday and said, look, we're going to pick a bunch of people for layoff next week. And we're not going to tell you whether you're going to be picked or not. But this week, we have a special deal. If you retire today and sign this settlement agreement, you get this enhanced severance package. If you don't sign it, you wait till the lottery next week and you get selected, these benefits are not available. And you have 24 hours to sign this agreement or not. So a number of them signed it. And after they signed it, they brought class actions claiming they were forced to sign these waivers and they should be able to keep the money and still sue for age discrimination. Because when they saw the people that were selected, it looked like it was age heavy statistically. Congress held hearings, the cases got dismissed from the courts, and Congress decided, you know, we need a law that changes what happened here in the Chrysler situation. So they developed a two-prong approach. In an individual termination situation, if you want to get a federal Age Act release, which means people over 40 years of age, you want a release from them that's valid on their age claim, you must give them at least 21 days to consider the offer. And after they sign the offer, if they take it, they still have 7 days to revoke it in case they change their mind. If you lay off 2 or more people pursuant to a program, then you have to give them 45 days to consider the offer. They still have 7 days to revoke. But in addition to the offer, you have to give them the statistical information on the ages of the workforce that was looked at for selection purposes. And then the ages and job titles of the people that you actually select. The reason for this, they gave them 45 days so they could find a lawyer and they could take those statistics to a lawyer and say, is this a good release for me to sign? Am I getting enough money for my claim? Is there adverse impact based on age because of the statistics? That's the information that they wanted to be available as the employer considered whether or not they should sign the waiver and give up their rights. So that's the background. Jeff, you want to make a few comments on some of that material?
I think the most important thing to remember, Lou, is that Older Workers Benefit Protection Act, and it's too bad because it's very hard to say OWBPA, layers in over everything else. It layers in over WARN. It layers in over Age Discrimination and Employment Act questions. It layers in over anything where you're going to ask for a release that involves someone protected by age discrimination laws, which means that the opportunity to make mistakes here is manifest. And you really don't have to look any further than Elon Musk to see how thoroughly it is possible to louse a situation up by not paying attention to the law. I think the one interesting comment Mr. Musk has made about his adventures lately was he told a joke. He said, how do you make a small fortune in the social media business? The answer is you start with a large fortune. And that is probably where he is going, because when you think about what has happened here, and I'm not going to get into the debate whether Elon Musk is a genius or something else, he did a huge number of layoffs. He did them willy-nilly. He did them without notice. And if nothing else, what he managed to do was to deprive himself of a workforce which under federal and state WARN, he could have kept on the payroll, keeping Twitter alive for him for either 60 days under federal law or 90 days under New York state law. Instead, he let them all go, and now he wants them back. So there is a lot to be said for thinking this stuff through.
Yeah, the WARN Act, I mean, we got the WARN Act, obviously. We've got these settlement agreement issues. If you have a massive layoff and we have made a mistake, there's been a mistake made in the settlement agreements or the attachments that go out and those waivers are not valid, you may have paid millions of dollars out and now face millions of dollars in claims. And the whole purpose of what we're trying to achieve is defeat it. Let's take a step back. And any workforce reduction needs good planning, right? It needs a process by which we're going to select people for layoff from the existing workforce. Now that might be, if we're following seniority, or it's an entire operation, or department or plant, you probably aren't going to have any discrimination because the selection criteria is obvious. Everybody went in this category. When you stop following seniority, which, you know, my hat's off to any employer that people and let the least productive go. I'm in a life.
Lou, we're having issues with your audio again. I apologize.
Right. Is this better? Is this any better?
Yes, much better.
Yes.
All right, I'll try to stay over here near the speaker. You know, with a reduction in force, our business has faced a downturn. It's taken a direction for the worst. And I liken it to people in a lifeboat. And, you know, we don't want to throw anybody out of the lifeboat, but we got to throw some out to save the rest. So I want to pick the best people, right, who are going to row us to shore. So you're probably not going to use seniority. So that means you need to select decision makers that are going to make this decision. You're going to need a process by which we make these selections. And we're going to check to see if we have adverse impact based on the criteria that we're using for the selection. And we're going to do what we need to do to avoid adverse impact in this selection. So you can defend anybody who doesn't sign a release and sues you for age discrimination or something else. You're in a defensive position because we've done it properly. We don't want the release to be your only defense. People don't have to sign the release. So good planning, obviously. Some of the nuances that we see when we get going with releases, whether they're individual or part of a reduction in force, one of the things I see people forget to do is sometimes we make a deal with someone. It's September. You're going to retire. I go to someone and I was going to terminate him. And they said, let me stay till the end of the year and I'll retire then. So, or I'll go into some other job temporarily for a while and then I'll retire. I'll train my replacement. All different options that we have, which have a last day of work in their current employment, but an extended day in the future for when they actually leave the company and leave employment. Now, you've got to figure out how you're going to do that, whether you're going to use irrevocable letters of recommendation, whether, I mean, my advice is that you cut your deal and have them sign a release at the time you make that deal. Those of you that are paying attention out there realize that any settlement agreement we sign only releases claims up to the date that the agreement is signed. So if I sign an agreement in September with a waiver in it, it only releases claims up to September. If I keep working the rest of the year and then I leave, that agreement doesn't release any claims that may have arisen in the last 3 or 4 months, which, depending on what your agreement says, might include them applying for a job and not getting it because it was clear their last day of work was to be the end of the January. So the way we deal with that typically is a 2-release process. They sign one in September. Attached to that agreement is an exhibit or an appendix that contains a second release that will be signed on January 1st. And they promise to do that. They promise to sign that release and deliver it on January 1st. They also agree to sign whatever papers are necessary to effectuate the release that they've signed in the agreement that's dated September or whatever. So you want to think about that 2-release process just in case your dates don't perfectly match up with the date that the person's signing the release. What do you do about claims that are you're unable to have released? ERISA claims, unemployment insurance claim, workers' comp claims. About the only nuance that I have in workers' comp claims is that I do often have people, if I'm worried about a workers' comp claim, which has a 2-year statute of limitations after they leave, I do recite that at this time they're not aware of any disability or work-related injury for that matter. They have no knowledge of any such injury or illness. And that avoids those, unreported illnesses or something that appears and they say, oh, I had this, I just failed to report it at the time I left. That's about all you can do. You can't do anything with claims that the law says can't be released. We talked about this 21 days and the 45 days. There's frequently asked questions on the website. But, one of the things to keep in mind here, Jeff, sometimes I forget it. You only need the 21 days and the 45 days under the Older Worker Protection Act if it's important for you to get the federal age discrimination release. you get the age release under New York state law, New York City or New York state law, without the 21 days or the 45 days. So if someone is under 40 years of age, there's no obligation to provide the 21 or the 45. If you're laying off 1,000 people, you might want to go through and see how many are under 40 and give them type 1 release, which doesn't have the 45 days in it and doesn't have the summary of everybody's age and titles that's being laid off, and provide that information to perhaps another 500 people and have it floating out there. And maybe only give the release to the people over 40. Maybe when you do your adverse statistical analysis, age is absolutely not an issue in the layoff. You might decide to fly naked and not get the release for the Age Act. The statute doesn't require that you give the 21 days and the 45 days. It requires that you give the 21 days and the 45 days in order for a release to be valid with respect to an age claim. If that's not that important to you, and you're willing to be self-insured on that and not have any protection because the statistics are so much in your favor, you might not even do it this way. Jeff?
Excellent point, Lou. One caveat, because we generally put in the consideration period and the revocation period as part of the total agreement, to follow up on your point, you don't want to give somebody the option to revoke the release of something other than an age claim. So, for example, if you absolutely have to get rid of a toxic employee and you're willing to settle to do it, and here I'm talking about individual releases, if you're sure that they don't have an age claim, take the release and get them out now. There won't be a consideration or a revocation period. If you think you may need it, one of the things you can put in for some protection, and this would go either to the 21 or the 45 if it's more than one person you're asking it of. When I put them in, I say, shall have 21 days from the date of this agreement to consider, or I'll have 21 days to consider whether to sign, but may sign it sooner at his or her discretion. Because you do have some employees who really want to get out for no other reason than they want that check. The one thing you cannot do is try to foreshorten or get an agreement to foreshorten that 7-day revocation period. There, you just have to suck it up. They can come in and revoke. There are things you can try to do to make it more difficult. I don't particularly recommend them. But
excellent points, Jeff. There's so many nuances to this. Let me throw a few out in light of what Jeff has said. First of all, you could limit in your agreement the revocation to only being the revocation of the age waiver, and the rest of the agreement is binding. The law does not permit you to incentivize the employee to shorten the 21-day period. In other words, I can't say, I'll give you $5,000 in severance pay and here's a 7-day 21 agreement. By the way, if you sign before 21 days, I'll give you an extra $2,000. The statute says that's illegal incentive. However, if you're you're agreeing not to start the payment period till after the 7 days is gone, that's going to be plenty of incentive for somebody to sign as soon as possible. And it gets into some of the issues that you should seriously consider, such as, do I want to pay this money out in a lump sum? Do I want to continue the payroll for a 6-month period instead of giving 6 months of severance pay up front? How much more control does that give me over the non-disparagement, confidentiality provisions I may have, non-solicitation clauses you may want to try to put in here? Those are some of the mistakes we see. Some of the other mistakes are not preserving other agreements that someone has signed. They have a clause in the severance agreement that says this is the entire agreement, there's no other. Well, we forgot that we had this person sign a whole bunch of confidentiality clauses, trade secret clauses, other agreements about non-soliciting employees or customers. You want to make sure you dovetail whatever you've got out there that you want to preserve. Don't throw the baby out with the bathwater in terms of a sole agreement clause that you may have. People forget, Jeff, I think you and I have both seen this in the past because we represent employers, but a severance agreement goes out and an inexperienced lawyer represents the individual, and they send back a nasty letter about how inadequate our severance package is and all the things wrong with the deal and all the demands. And I've had clients get upset because they thought the severance package was generous and they don't really need the release. And we send a letter back. I've had to send a letter back to that union, that attorney, saying that, geez, we got your counteroffer, which we took as my cousin Vinny used to say, a counteroffer is a rejection of the original offer. And therefore, we're withdrawing our offer. Yes, you had 21 days to consider it, but you actually rejected it with your counteroffer. Every case I've looked at when I've done the research on this issue says that while the statute says you have to give them 21 days to consider it, like any other offer, it may be withdrawn before it is accepted. So the plaintiffs out there need to be careful with what position they take in terms of this severance offer that's on the table.
Yep, when you tell someone that they've rejected the offer and you're done, it certainly engages their attention. Well, you also mentioned the non-disparagement clauses, and that comes up with some frequency because in a tense employer-employee situation, the employer often does very much want a non-disparagement clause. The fact of the matter is, it is very difficult to enforce a non-disparagement clause. And even if you had an extreme case where you could get a court involved, it's going to take time. Time is not your ally here. So to Lou's point earlier, self-help is going to be the way to deal with a non-disparagement clause. If you want a non-disparagement clause for 6 months after the employee terminates, make the payout take place over 6 months. There you do have some control over it. Would you agree with that, Lou?
I do, Jeff. And I don't think anything, if you really need a non-disparagement provision, you need to take a lot of time with that clause. You need to think about a liquidated damage clause in addition to the payment over time. You need to decide, how am I going to enforce this? It doesn't do any good for me to have a non-disparagement clause, which I have to go into court publicly to try to enforce and inform the rest of the world that didn't hear about it the first time is now going to hear about it the second time, right? So am I going to have arbitration, private arbitration that keeps it quiet? You got to spell those rules out. You got to talk about the expedited basis of it, the authority of the arbitrator on an expedited basis to be able to issue an injunction. What papers get filed if they have to move to confirm that arbitration award in court? Because again, going to court may be, prohibitive for you because you don't want to, call the disparagement in on yourself with the disclosure. Same thing with confidentiality. And speaking of that, Jeff, we've got a statute in New York, which is fairly new. It started off out of the Me Too movements for sexual harassment complaints or claims, prohibiting confidentiality in settlement agreements if you were settling a sex discrimination case. And then when everybody else complained about what's so special about a sexual harassment case compared to all the other discrimination cases, the statute got expanded to all discrimination cases that are being settled. In New York, if you want an enforceable confidentiality provision, you have to have a separate agreement. It can't be in your settlement agreement. And it has to be at the preference of the plaintiff, the complainant. They have to be asking for confidentiality. So this was a tension, right? The Me Too movement was upset because a lot of sex discrimination, sexual harassment cases were bought out and swept under the rug. On the other hand, there were many complainants that said, listen, I want my claim to be confidential. I don't want the world to know they filed a sexual harassment complaint against my employer. So the compromise was that it has to be the preference of the complainant. There has to be a 21-day, and that period cannot be shortened. It can't be signed early. It's 21 days for them to consider the agreement of confidentiality. And they have 7 days to sign that, and they have 7 days to revoke it. So 7 days from when they sign that agreement, the 21 days has elapsed that they've had. That agreement will be enforceable 7 days after it's signed. So you're looking at a 28-day period to resolve these in New York if you're going to have a confidentiality provision. Which leads me to my other concern, which is with people working remotely, you may have different state laws that are going to cover this settlement agreement. You got to think about choice of law, venue, where to enforce it, and what state are people in that are signing settlement agreements with us. I'll stop there, Jeff.
Okay, I just want to leave everyone with one thought. We're coming up on the labor lawyer's favorite time of the year, which is called the office holiday party. We're going to have the first holiday parties for a couple of years in many instances. Just remember, an unscripted, unsupervised, unwatched holiday party is full employment in the following year for labor and employment lawyers. So be careful out there and have a wonderful holiday.
Well, Lou and Jeff,
well said.
Yeah, thank you so much. I think that I can summarize by saying, if you want to offer a separation agreement to an employee, you want to try to settle a discrimination claim, there are a lot of legal pitfalls that you might fall into. And please make sure to consult with an attorney before you do that. So thank you, Lou. Thank you, Jeff. Appreciate the time. Thank you to everyone for joining us. If you have questions, as always, please feel free to leave them in the Q&A or in the, I think there's a follow-up review that you can fill out. Please let us know if you have any topics that you want us to cover or are particularly interested in. We're happy to do that. Great to see you all, and we hope you have a great Thanksgiving. We'll see you next week.
Have a good holiday, everybody. Thank you.
Take care.
Great to see you guys.